Hardy.
Just one question for the panel. How would white man's law have to change? What would have to happen in white law to allow Aboriginal law to function beside white law?
Okay, I think for that question, would Glenn or Michael, would you be able to tackle that?
I'll have a go at it.
Mike.
To a large extent, the law of Australia operates side by side with Aboriginal law anyway. Aboriginal law is very strong, as you've heard tonight. Not just from the documentary that you've seen, it still exists, it still flourishes, but you've also heard it from the panel members from different language groups that it flourishes elsewhere besides the Warlpiri Nation. I do believe that the Australian law should do more to recognise the Aboriginal law and to honour it. I'm sorry that the people involved in the documentary seem to think that non-Aboriginal people did not care about Aboriginal law and customs. Speaking just for myself, I think that is wrong, that we do honour and respect them and wish them well and hope that they thrive and continue. Where we seem to come to the tricky point is what is loosely called the payback. That was mentioned in the documentary in the context with a death that had occurred. And I think the question from the back of the audience earlier related to what about other crimes, other offences against Aboriginal law, is payback used for that or not? And I don't know the answer to that. I'm not an expert on Aboriginal law. One of the problems that non-Aboriginal people have is that we are dealing with not simply one Aboriginal law, but many different Aboriginal laws for different Aboriginal groups. In the southern half of the Northern Territory alone, there are 16 different language groups, all with their 16 different laws, similar laws. Many of them are similar, many are interrelated, many may be identical, but they are 16 different language groups here. Then you have a very large number of different language groups in the top half of the Northern Territory. And then you've got Western Australia, Queensland, South Australia, and so on, where there are other different language groups, perhaps with other different laws. And that is one of the difficulties that confronts non-Aboriginal lawyers, is to know exactly what the law is in any group that we're going to. I think that the white man's law should have made more of an effort to understand Aboriginal law. If we go to Largermanu, we should know more what the law is there and honour it and take it into account. To a large extent, that's done every day in the courts. Once guilt is established, you then pass into the sentencing phase, and the lawyers who are representing the defendant, if he's an Aboriginal person, are expected to tell us what that person's language group is, to what extent the Aboriginal law played a part in the commission of the crime, whether or not that person, the defendant, is a traditional person and practices Aboriginal law, or whether he has lost his way, that sort of thing, the background generally, and that all of that is taking into account Aboriginal law. But it seems to me that where we get into the difficulty is with what has been called payback, which involves physical punishment of an accused person by Aboriginal people. I personally think that the law people in this country are far too precious about that, and that we should take it into account. In the time that I was here as the Deputy Chief Magistrate, On every occasion when I was asked to release a person charged with homicide on bail so that they could go back and face the victims and the group that they came from, I granted that bail. And I must say this, that the defendant was always very glad to return to custody afterwards. But I am told, I got feedback on these matters, that on every occasion when this happened, it was precisely as has been said here by the other speakers tonight. It does settle the community down. There's a word, assuages the grief and the anger of the victims' relatives, and it enables the community to function again, and it certainly takes a burden off the shoulders of the person who's accused as well. Not only is it taken into account in that way that I have granted bail for this to happen, I understand that people are not doing that now, and I don't understand why, but I'll give you a clue as to how this could be done a bit better. What is wrong with simply saying to the court, they're not silly, they'll know what it's all about, but that the presence of the accused person is required back in the community for a short period of time to undergo ceremony without being specific as to what the ceremony is. I can't see what's wrong with that. Does that answer the question?
Yeah. Yeah. Thank you.